All right, so let's get the show on the road. Do you want to do the birthday challenge one more time? Just
I
for
I do. I do. Welcome everybody to Commercial Collection Agencies of America's 20-minute talk. We are so excited again. I swear I say this every time, but it is the truth. We have record registration for this 20-minute talk. So kudos. Um, I am going to turn it over to the President Emeritus, the past president of CCA of A, Umberto Matz. He is the originator of the 20-minute talk. Before I do that, you'll see in the chat that there's a whole bunch of birthdays. We're having a birthday challenge, a contest. So if you put the month and year, I'm sorry, the month and day in the chat of your birthday, we're going to reveal the criteria for the winner of $100 off of your any conference registration, semi or annual, or $100 for, and it is a free registration for the senior collector course. So we will reveal the winner at the end and the criteria. But for now, I'm going to turn it over to Umberto Matz, who will introduce the TMT speaker. Umberto?
All right, well, welcome everybody. Thanks for joining us, and in particular, Joe, thank you for joining us. We're really looking forward to your presentation. Um, so let me introduce Joe Shur. I'm sure that you all know him. Um, Let me give you his bio. After graduating from high school at 16, college at 20, and law school at 23, underachiever, Mr. Schur began his legal career at the Monroe County District Attorney's Office in Rochester, New York. He was provisionally admitted to the New York State Bar as an assistant district attorney on September 11th, 1989, and was formally admitted on January 11th, 1990. Joe quickly built a reputation as a relentless prosecutor. In an unsolicited letter to the Monroe County District Attorney in 1993, the late New York State Supreme Court Justice Eugene W. Bergen wrote, "Having been a courtroom observer in the Hall of Justice for the last 30 years, I believe that Mr. Schur is one of the finest prosecutors I've seen. He has an excellent courtroom appearance, gifted with a strong voice, pleasant manner, and a quick mind. He establishes good eye contact with the witnesses and the jurors and is not controlled by the yellow pad, as so many lawyers are." In 1996 alone, Joe indicted more than 70 felony cases and secured convictions in 13 of 15 trials. On the strength of his performance at the district attorney's office, he was recruited by the law firm of Relin, Goldstein Crane in 1998. In his 21 years at Relin, Goldstein Crane, Joe has represented creditors with the same energy, enthusiasm, and tenacity that he displayed as a prosecutor. And he spends the majority of his time litigating commercial and retail collection matters in various New York state courts. He also represents creditors in adversary proceedings in bankruptcy court. Relin, Goldstein Crane is a affiliate member of the Commercial Collection Agencies of America, handling commercial collection matters in New York, Vermont, and Maine. Welcome, Joe. We're
Thank
looking
you.
forward to this.
Thank you very much. I appreciate it. Good afternoon, everyone.
Good afternoon, Joe.
It's
Hi, Joe.
it's really a pleasure to be here. My bio is slightly dated. I've been here at 28 years now at Relin, Goldstein Crane, and the first time they offered me the job, I was so happy prosecuting major felony offenses that I said, I sleep like a baby at night when I convict a murderer. I don't know. Do I want to handle this collection work? So the first time the job was offered to me in 1997, I passed. I was waiting for a murder verdict after I turned the job down the first time from Paul Goldstein. And as I'm waiting for the verdict, I looked around the courtroom and I realized that everybody in the courtroom was making more money than me. I was just dating my wife at the time. I said, it would be nice to have a house, right? The court reporter was making more. The court deputies were making more. The judge was making more. The defense attorney was making a lot more than I was. So I got a verdict, and it was a murder case, a murder for hire. And the defendant in that case escaped the death penalty, which was in effect in New York at the time. And because he was only 17 years old. If he was 18, he would have been eligible for the death penalty. I got the guilty verdict and I called Paul back and I said, Paul, I'm ready to come. I'm ready to be your attorney. One quick war story is that they brought me on to be the litigator. Now I'm the managing partner some 28 years later. They brought me on to be the litigator. And my first case, we were representing Citibank in a deficiency judgment. And I had a trial on it, and probably within 2 or 3 weeks of being here. And I was used to not showing the judge or the jury, just being indignant with the judge or the jury. And so I was basically pounding on the podium, pointing at the defendant. He owes the money, Your Honor. He got the loan. He didn't pay the loan. There's a deficiency judgment. He's got to pay that money. And the defense attorney was sitting there like this next to his client. I didn't know who was more afraid. By the time I got back, the attorney had already called Paul and told him that about my performance in court and how I was very animated and probably more enthusiastic than any collection attorney he'd ever seen. And Paul brought me in his office and said, Joe, it's a civil case. It's fine to represent the clients zealously, but there's a certain decorum on the civil side that perhaps you didn't have when you were a prosecutor at the DA's office. So I guess I learned to temper that enthusiasm, if you will. But nevertheless, with that backdrop, I decided that the best place to start my 20 minutes would be with judgment enforcement. And the reason I say that is just about any lawyer in this town can get a judgment by suing and serving a defendant, and then they get the judgment, and most do not know what to do once they get the judgment. The hope is that we're trying to settle the case at every single milestone with the initial demand letter. After they're sued and they get served with the summons and complaint, perhaps they call the office and want to work out a payment arrangement. Those are the easy ones, right? It's ultimately when you get the matter reduced to judgment, that's where the rubber hits the road. That's where we have to decide, how quickly can we liquidate this judgment? Because if they let the matter go to judgment, chances are there are other creditors that are after this particular judgment debtor or judgment debtors. So if you don't mind, I'm going to share my screen for just a minute. And sharing the screen now. So I created this workflow process, and this workflow process assumes we've sued the debtor, served the debtor, have the matter reduced to judgment, and now what do we do once we've got the matter reduced to judgment? I like to think that that's where we distinguish ourselves from other firms, is our ability to liquidate the judgment. In New York, I just want to give you this information as well. In New York, Supreme Court is our court of general jurisdiction, and 61 of 62 counties in New York are on the electronic court filing system. Allegheny County is the only holdout, and there's no, I guess they don't have any plans to be on the electronic court system anytime soon. So when you see, for instance, on this workflow process that we have a case reduced to judgment rather, in Supreme Court, it means that it was sued in our court of general jurisdiction. The court above Supreme Court is the appellate division, which is the intermediate appellate court or appeals court. And the highest court in our land is the Court of Appeals. So in most states, it's the Supreme Court of that particular state. In New York, it's the Court of Appeals. So we've got the matter reduced to judgment. And I'll use an example, one that comes up often. Let's just assume it's a material supplier to a contractor, and there was a credit application and a personal guarantee. That happens a lot. I'm sure that many of you have cases like that you send out to attorneys after your in-house efforts have stalled out. Once we reduce the matter to judgment, it automatically creates a lien against any real estate that the debtor owns in that county. So if the debtor has 15 pieces of property, and let's pick Erie County, which is where Buffalo is located, we have a judgment filed with the Erie County Clerk's Office. That judgment automatically creates a lien against each and every piece of property the debtor owns. If the debtor owns a piece of property in Rochester, Monroe County, we have to transcribe that judgment to Monroe County. And then again, any piece of property that the debtor owns in that county is encumbered by the judgment lien. So there's no extra step that's required in New York. Simply by filing the judgment, you've got a lien. That's helpful because the debtor wants to sell any property, they've got to address the lien. Often, a lot of you will reach out to me saying, oh my God, the client has received a notice that there's a foreclosure proceeding going on. Well, I respond to these probably daily. What that means is that a title search was run by the mortgage company who gave let's say a personal guarantor, a mortgage, and they're foreclosing on his home. When they foreclose on the home, any encumbrance, any judgment creditor, any lienor must be notified of the foreclosure proceeding because they have an interest in the property. Due process requires the judgment creditor to be notified of any type of foreclosure proceeding, because when that foreclosure goes through, anything that was filed in against the property is going to get wiped out. Anything that gets filed after the mortgage. So you know probably firsthand, when you purchase a home, there's a deed and the mortgage get filed together. So you buy a home, you get a mortgage, they're filed together at the county clerk's office. In New York, it's first in time, first in right. And you'll hear me say that more than once this afternoon. So if there's a mortgage and then a judgment's filed, the mortgage takes priority. If there are 3 judgments that are filed, again, first in time, first in right. I always say that's why we should be the creditor that strikes first and hardest, because if there's a surplus, and it happens from time to time, the judgment creditors get paid in the order in which their lien was filed. So we'll get notified of a surplus, and we routinely file a notice of appearance on behalf of the judgment creditor. If there's a surplus, we'll get notified, and we can state claim to surplus money. It doesn't happen often, but when it does, again, your priority is determined by how quickly you reduce the matter to judgment, which has created a judgment lien on the real estate. So that's the first box. I'll use my cursor. That's the first box. A lien is created against real estate against the judgment debtor in the county. A common question is, if the judgment's for $10,000 and the debtor owns 10 pieces of property, is each property encumbered by a $1,000 lien? No. Each of those 10 properties is encumbered by a $10,000 judgment. The first thing that we do once we get the matter reduced to judgment is I'll jump to this box, which is the bank restraint. The bank restraint is a very effective tool in New York State. You can issue a series of bank restraints to all the banks in the area, but you can only issue information subpoenas to those banks if you have a good faith basis to believe that they're banking at a particular bank. That's why the credit application is so helpful, especially with personal guarantees. So if you see that they're doing their business at a small bank like Tompkins County Savings Bank or Eastman Savings and Loan, that's important information to have, because just a bank sweep of the area might not restrain a bank account. What we do, and I don't think I'm giving away the recipe to the Coke formula here, but what we do is we recognize that most judgment debtors are doing business within a 3-mile area of where they are. So we'll basically make a circle around where the debtor lives or where the debtor is doing business and restrain all those banks in that area. If we know based on a credit application that the debtor was doing business at a particular bank, we'll also issue an information subpoena to the bank so that we can find out information about the debtor, the bank account, the balances, etc. I was just telling Annette earlier that we had 2 calls today based on bank restraints. Both resulted in a conditional release. When a bank gets a restraint, in New York, they double the judgment amount. The first instance today was a $21,000 judgment, so the bank was holding $42,000 of the debtor's money. I always presume that the debtor has sufficient funds in the bank account to satisfy the judgment. I talked to the judgment debtor. He said, just take the $21,000 and release the balance. So we issued a conditional release to the debtor's bank account. It's a twofold process primarily. We have to send the conditional release to the debtor's bank account, in this instance, Chase, and the debtor then has to sign off on it as well, authorizing the release to our firm as the attorney for the judgment creditor. At that point, once the judgment debtor has authorized it, once we've issued the conditional release, the bank issues a check, a certified check for $21,000 in this instance. It's a certified check made payable to my firm as attorneys, and Chase is a little slow, so it might take 10 days or 2 weeks to actually get here, believe it or not. But at that point, once we get the funds, we'll then satisfy the judgment. The conditional release letter basically says release the debtor's bank account once the certified funds are issued to my firm as attorneys for the judgment creditor. So that's a very effective tool. That one works great. But the question is going to be, what do you do if the debtor's out of business? Some of the other things that we do right in this area, I'll put my cursor there, is if the debtor's out of business, we frequently go to the New York State website for unclaimed funds. The debtor's no longer operating. That means they're usually not cashing checks that might be sent to them. So a really good way to try and locate assets is through the New York State Controller's Office. They have a website for unclaimed funds. And if we find some there, we'll send the marshal out. I can give you one good war story that resulted in $27,000 that was recovered based off of that website. But a lot of times it's $10, $20, $200, $600. It really spans the gamut. But the largest amount collected off the website was $27,000 from a judgment debtor, a business that was out of business. We will issue information subpoenas to the judgment debtor. We'll try and bring in the principals of a company. We'll bring the judgment debtor in. Sometimes we work out mutually agreeable payment plans. If that's the case where we work out a mutually agreeable payment plan, basically we will withhold judgment enforcement activities as long as they make a certain amount of payments. The bank restraint works in connection with that because often when we restrain their bank account, they may only have a portion of the judgment in their bank account. Once a debtor calls us up and says, "You've restrained my bank account, but I only have $4,000 in it," experience has taught us that we're not going to take the judgment debtor's word. So we'll issue a subpoena and fax a subpoena, information subpoena, over to the bank to confirm how much is available. We report that to the client, and the client will frequently say, "Okay, the judgment's for 20, the debtor's got 5,000 in his bank account, wants to pay $3,000 a week, a month, whatever. They just need 2,000 for payroll." We let those tough decisions lie in the hands of the creditor. They could take the $5,000 now, but probably shut them down, recognizing there might not be any money down the road, or they could take $3,000 and play the long game. And the judgment debtor is fully aware of what we can do in the event that they don't honor the payment plan. And we've had some creditors who said, "Take the $5,000, it might be the only money we'll ever see." Others say, "Take the $3,000 and we'll," as I said, play the long game. If we work out a payment plan and they've made 2 or 3 payments, and then all of a sudden they stop making their payments according to the settlement agreement, then they've defaulted. We often follow up. We use our computer system, follow up with a call or a letter to the debtor. Frequently the one who's making the call to the debtor. We're sending emails, asking questions. What's happening? What's going on? Again, if they don't respond, we can't issue more than 1 bank restraint in 1 year, according to the law. But what we can do is issue a property execution to the sheriff, to the bank, where we know they're doing their banking. So the sheriff can then go out with a property execution, go to their bank, and then attach their bank account and collect whatever's in the bank account. At that point, once it's with the sheriff, it's beyond our control. An important consideration with a property execution is that when you send it out to the sheriff's going to collect not only the judgment amount and calculate the interest. Sheriff also collects poundage. That's something we remind judgment debtors of as well. The sheriff's poundage is 5%. So the sheriff's going to collect, we'll call it, just using round numbers, the judgment amount plus interest plus 5%. So it obviously, if the debtor wants to resolve the matter, I guess, quickly in the most economical way, they're going to want to avoid the sheriff because it's just going to cost them more money. And then once the sheriff restrains a bank, the bank sends the money to the sheriff takes their 5%, remits to our office, and then we ultimately remit to the forwarder who sent us the file. If, going back here, let's assume a guarantor now didn't have any money, we've stalled out on our collection efforts and 2 years have passed, and now they're going to sell their home, and they ask for a judgment payoff letter, which is common. Sometimes judgment debtors, the guarantors, will be selling their home, their last asset, and because they want to obviously capitalize on the equity, property values have steadily increased in the last 7 years here in New York. They're going to sell their house and we'll get a request for a judgment payoff. We calculate all the 9% interest on top of the judgment. Judgments gain 9% interest here in New York, and we'll send a payoff letter. If the house is sold, the attorney will send us the payoff letter to hold with the payoff funds to hold in escrow until we file a satisfaction piece. Once we file the satisfaction, then satisfaction is filed. We provide a timestamped copy so there's clear title. That is, the judgment lien no longer encumbers the real estate that was sold, which previously was owned by the judgment debtor, guarantor. And then we remit the funds to the client, and that's a paid in full or settlement in full. Sometimes a guarantor, uh, the business fails, but we have a judgment against the guarantor. Now, the guarantor might not have anything. One thing to be mindful of is when you issue a bank restraint, there is an exemption in New York. The exemption on an individual account is 240 times the minimum wage, which is now $16 an hour in upstate New York. So doing the quick math, that's $38.40. The first $38.40 in any bank account of the debtor, judgment debtor, I'm going to use it, I'm speaking about a guarantor now, whose business has failed and has to work for a third party. The judgment debtor's bank account is going to be protected up to $38.40. Anything above $38.40, we can restrain and we can potentially levy on. Most judgment debtors or guarantors aren't going to have that amount of money in their bank account, especially if their business has failed and several creditors are chasing them. In which case, we find out where they're working now for a third party, and we will issue an income execution. In New York, an income execution we can basically garnish a debtor's wages up to 10% of their gross wages. So 10% of their gross wages, we issue an income execution. It works in 2 stages in New York. The first stage, the judgment debtor is served by the sheriff's department. And then the sheriff, if the debtor cooperates, the judgment debtor cooperates and shows the sheriff the paycheck, I make $2,000 a week, I'll pay you $200 a week. It saves the judgment debtor the embarrassment of his employer, knowing that his wages are being garnished because a judgment's been issued against him. If the judgment debtor ignores the first stage, the sheriff then serves the second stage on the employer, and then the employer takes 10% of the judgment debtor's gross wages and sends it to the sheriff. I will tell you, based on experience, once we find a place of employment for a guarantor whose business has failed, that typically it will take about 120 days for an income execution to start performing, assuming we have a good place of employment and assuming the judgment debtor is still working at the employer that we've located. Some of the other skip tracing tools we use things like the work number. We run Experian credit reports. Once we've got the matter reduced to judgment under the Fair Credit Reporting Act, we can run a credit report. What I like to do is look and see what their credit score is. It might be as low as 500. It could be over 700. It really depends. The credit report's good for a lot of things. You can see, where they've got, let's say, bank financing on a car, or where they applied for credit last. With an information subpoena, you can subpoena the information from a credit grantor as to where the debtor has applied for credit. So if they applied for a car loan, let's say at Bank of America, we can subpoena that information from Bank of America to see what type of information was submitted to that credit grantor when the debtor was trying to get credit. I'm looking at my time. How am I doing on time?
You're good.
Okay.
This is all good information. We have a question.
Sure.
We have 2 questions.
Sure.
If the bank account is in the name of the guarantor and the spouse, how is that handled, Joe?
You'd have to make a turnover order. You have to actually make an application to the court. You'd have to file a motion for a turnover order, and there will be plenty of defenses. In a bank account, for instance, any money that, if they can show that it came from an exempt source like Social Security, it's going to be exempt. If it's less than $38.40, using my example in upstate New York, it's going to be exempt. But you have to make a motion before the court to have the court determine how much of that money the judgment creditor is entitled to.
Okay.
Typically, I've seen, okay, it's been half. So if there's $5,000 in the bank account, it's jointly held. We've seen judges say, okay, the judgment creditor is entitled to half. But a motion has to be made before the court. I will say though, that takes time. And the last thing a judgment debtor wants is his or her bank account restrained for a protracted period of time before a judge can listen to a motion and make a decision and ultimately have their bank account released.
The other question, thank you, Dennis, for this question. It says, unemployment garnishment, do they have to be renewed every 3 months?
So if they're receiving unemployment insurance benefits, is that
No, on the wage garnishment.
Oh no.
And
The
Dennis, you
wage
can unmute if
Yeah.
I didn't read that properly. I believe you mean on wage garnishments.
Yeah.
Correct, on
Yep.
wage garnishments.
They do
Not
not have to be
Thanks.
unemployment.
renewed. They do not. Once it's in place, it stays there until the judgment's satisfied. Now, one important thing brings me to another topic. It's very important. We talked about first in time, first in right. If creditor number one gets the judgment first, but creditor number two gets the judgment but finds the place of employment first, and both issue income executions, but creditor number two, even though it was entered second, files the income execution first, creditor number two gets paid before creditor number one. It's first in
Because
time,
they
first
found the source?
because they filed the first income execute. They had the
Oh.
first income execution to the sheriff first. It's whoever gets the income execution to the sheriff first. Now, you can only have one income execution in place at a time in performing, which means judgment, in my example, judgment creditor number two has to get paid off before the second judgment in line will then get paid. It's an important consideration because it shows you that you've got to be vigilant. You've got to stay, you've got to make sure you're looking for, you're running the work number, you're looking for places of employment, you're verifying employment. Again, even though you entered the judgment first, if your execution went to the judgment second, whoever has the first execution is going to get paid, even if there were 15 other judgments filed before that judgment creditor with the first execution got that execution to the sheriff. Does that make sense? Everyone follow me?
Yep.
Great. So that's a very important consideration. Sometimes we'll issue an income execution and the client will ask, what's happening with the income execution? And the sheriff may say there's a previous execution in place. We've had instances where 2 or 3 years go by, and then we start receiving funds from the sheriff on the income execution. So, back to, I guess that was Dennis's point, you don't have to renew the income execution. Once it's in place, as long as the debtor is still employed at that location, the income execution should be performing unless there's a prior income execution in place or a child support enforcement order in place. Or don't forget, the state and federal governments always get paid of everybody else. So you're not going to, New York State and the IRS also, they take priority over a judgment credit.
Hey, Joe, I have a quick question.
Sure.
So in the example that you started out with, it was a contractor
Yes.
and hadn't paid for materials or premiums, insurance premiums, or anything like that. In California, if we have a judgment against a contractor, we can submit that judgment to the contractor state licensing board, and they can then decide whether that contractor's license should be suspended or not. Do you have anything like that in your jurisdictions?
We don't routinely handle anything like that. It just doesn't exist.
Okay.
I'm sure there are licensing. For instance, if there's I can tell you on subrogation cases, if anybody who's participating here has a subrogation, a subrogation case, you can suspend judgment debtor's license, which we've done from time to time. So if there's an accident and someone's uninsured, and then the insurance company pays its insured and then is subrogated to the position of its insured, and we sue because the other vehicle was uninsured and get a judgment, we can suspend the license. That's an effective tool. Because the next time they get stopped for a traffic matter, their car is getting towed because they're operating a car with a suspended license. But as far as the contractors themselves, there's nothing like that we're doing on a regular basis to check that out necessarily. I think the more effective way to collect on these is with the personal guarantees, because at the end of the day, if the judgment debtor, once it's an individual debt, there are only 3 ways out. It's either payment, bankruptcy, or death without an estate. Those are the only 3 ways out once you have the guarantor, a judgment against the guarantor. And it may take a protracted period of time. I recognize that. Sometimes, we'll have judgments open for so long. Even the forwarder will say to me, is it time to close this one out? And we'll take one more run at it, run another, run a search, run, one of the skip tracing tools that we use, TLO, whatever, just to see what's out there. But even though we close it, it doesn't mean that sometime later on, they're not going to sell their real estate, right? Now, a question comes up from time to time, can you sell their homestead, their real estate? The answer is, you can, as long as there's no mortgage that's ahead of you as a judgment creditor. But there's a huge homestead exemption depending on where you're located within the state. and each one of the residents, so if it's a husband and wife, they each get a homestead exemption. So often it's not worth the investment, the capital investment. You got to run a title search and conduct a foreclosure and everything else, and then recognize the first money that the sheriff collects, that has to go back to the judgment debtor and whoever else lives in that house under the homestead exemption. So it's just not worth it. If it's commercial property, that's another story. Again, it could be subject to a mortgage as well.
So Joe, just to clarify, one time for a bank garnishment per year, correct? And then it's got to go to the sheriff?
That's correct.
Okay. Robert, there's your answer.
So this is just my my thumbnail sketch of what we're doing. The idea, at least in our practice, is if we can't resolve it with the judgment debtor, actually, if we can't resolve it with the debtor, I'll call him, we want to get the matter reduced to judgment as quickly as possible. And the reason for that is the judgment gives us the key to their bank account. A judgment lets us, levy on property, intercept money owed to them by third parties. If we're conducting, for instance, a debtor exam, information subpoena to the debtor, we conduct a post-judgment debtor exam. We're going to want to find out who owes that debtor money. If a third party owes that debtor money, we can intercept that money with a third-party restraining notice, which we'll have served by the sheriff's department on that third party. And it basically says, don't pay the judgment debtor, pay Relin, Goldstein, Crane as the attorneys for the judgment creditor.
Roxanne's got a question. She says, does that apply to a debtor realtor as well as filing a lien against their license?
Well, we have yet to suspend or apply against anyone, a debtor realtor. Often the good news is with debtor realtors is that they're commissioned. So we'll find out where they're working, find out their listings, and issue third-party restraining notices, which is a much more effective tool. So if that realtor who's a judgment debtor is selling a house and they're entitled to, in New York, it's usually 6% commission. It may be split with another realtor. We would send out a third-party restraining notice. Most realtors are 1099 employees anyways, which brings me to another good point in just a moment. But we'll be able to restrain any money owed to that realtor with a third-party restraining notice. In New York, if the judgment debtor is working as an employee, you can garnish their wages up to 10% of their gross wages. If they are a 1099-C, you can intercept the money that's going to be paid to them 100% from the employer. And that would apply, let's say, in a realtor situation. If they're a 1099 employee, we can send a third-party restraining notice. The 10% limit does not apply.
So, Robert, you can unmute
Oh,
if you
sorry about that.
unmute. Yeah,
And
Joe, we said one time for a bank garnishment, but what if you don't capture the entire amount? Still one time?
Still one time within a
Okay.
year. So that's why, ordinarily, if it's a business and they're still open and operating, and if they're ignoring us, we can't get them to adhere to the payment plan that they had worked out. We issued a conditional release for $5,000. They're going to pay $5,000 a month until the judgment balance of $50,000 is resolved. And they're not communicating, they're not responding. We'll just send the sheriff out to levy on the bank account.
got it. And then in relation to the poundage, so let's say the sheriff has to serve the property levy. Is that poundage percentage paid by the creditor, or is that get paid by the debtor, or is that
It
added
gets
to the
paid by the
judgment?
debtor. So
Got
the sheriff, don't forget, the sheriff's going to collect 105%. I just use that as a round number, 105% of the outstanding judgment balance with interest. And they're paid 5% of what they collect. So if they collect $10,000, you can expect that there's going to be 5% or $500. So the net remittance to my office would be $9,500. Now, what that means is, in that instance, right? So only $9,500 would be credited toward the judgment balance, not the $10,000.
Quick question. When you send out on the informational subpoenas, okay, do you, especially on personal liability, do you pull credit reports and then send subpoenas out to for instance, the individual credit card companies, or for copies of last payments and banking information?
Yes. So we'll any place that they are current on their loan, for instance, if they're current on an auto loan, we'll subpoena that information. We like to see that they're current on, because the penalty is swift if you don't make your car payment, right? They take your car. So if they're current on their car loan to GMAC, we'll issue a subpoena to GMAC to find out how they made their payment.
That's a great strategy.
Yeah. Joe, this has been really great. I always look at where we start in the audience, and then I look in the middle, and I look at where the end is, and you have definitely held the audience. So excellent presentation, really great information. We all are very appreciative of you. And we're all appreciative of the audience. Annette, you want to close us out with some housekeeping items?
Certainly. Just a couple housekeeping items I put in the chat. Next Thursday, CCA of A is proud to impanel a group on the accountsreceivable.net webinar called Advanced Asset Location Strategies. So please join us for that next Thursday. If you're on this TMT 20-minute talk, you will get an email. And then again, our next 20-minute talk will feature Brian Cloud from Cloud and Willis, and that's on March 12th. Okay, the big reveal. The reveal is the criteria for winning the either $100 off your registration at the semi-annual or a free CCTI is that you have a birthday during the dates of the semi-annual conference. Now, do your math. April 19th, there he is, April 19th through the 22nd. He's do it again, Larry. Congratulations, Larry. Larry's birthday is on April 21st. Ashley, you came really close, girl. You came close, but Larry beat you out because his birthday is actually during the conference.
Wah, wah.
Wah, wah, wah.
I thank everybody for joining us. A special thank you to not only my colleague, but my friend Joe Shur, and of course to Umberto for stepping in. He is the originator of the 20-minute talk, and we are grateful not only for his great idea, but for his continued involvement. Everybody have a great day, and we will see you next week and next month.
Thank you.
Thank you.
Thank you, Umberto.
Thank you.
Thank you, Annette.
Thanks, Annette.
Thanks, Joe. Great job.
Thank you.